SJC-12902, Maureen Blake, v. Hometown America Communities, Inc.
We have Mr. Kraus first.
Yes, Justice.
We'll hear from you.
Thank you. May it please the court, Robert Kraus for Hometown America Communities, Inc. and Hometown Oak Hill LLC, the appellants. Your Honor, Justices, we believe that Justice Edwards, without citation and without a standard, misinterpreted the language of General Law, Chapter 140, 32L, subsection 2, in the words, change of rent for manufactured home residents of a similar class. We ask that you overturn that summary judgment decision or remand it back with respect to the matters of the rebuttable presumption or issues of fairness associated with the statute. Our argument is essentially this one of statutory interpretation. And this court has particularly looked at different elements. And I quote Justice Kafker in his Dorian v. LVNV funding, words of the legislature, legislative history, and agency interpretation. In this matter, Justices, you cannot treat a prospective resident, an applicant, the same as someone who is a resident and afforded all the protections of GL Chapter 140 and the regulations. It's unreasonable, it's not commonsensible, it's absurd, it's not the plain language. Those are all standards enunciated very clearly by this court, whether it was Justice Link who wrote in Commonwealth v. Morgan about having a harmonious interpretation that common sense should lead the way, and particularly what Justice Budd wrote in Kerry v. Commonwealth, where a challenge to an agency interpretation has a formidable burden. The legislative history is not clear. The legislation with respect to manufactured housing started in 39, has been amended 8 times with a variety of different matters, but this section has not been amended. What you can see consistently throughout the legislation and the changes is fairness. Fairness to the owners, fairness to the tenants. And the statute provides and the regulations provide that fair market value is what controls when someone enters. Not a prospective, not a tire kicker, not someone who's looking to come in, but who is a tenant, a resident. The agency interpretation here is a very important element, and I ask that you pay careful attention to it. The AG since '93 has had the ability under 32S, section 32S of this chapter, to promulgate regulations interpreting Chapter 140. And it also provides a guide. The latest iteration is 2017. It's called the Green Book. It's sort of a Talmud of learned people's interpretations of cases and the regulations and the statute. There's also a letter, amicus curiae letter, from Assistant Attorney General Daniel Less, which was dated August 18th, which I think you should pay careful attention to. And lastly, as I've made reference to, the Chelmsford Mobile Home Master Lease. Why is that so important? It's a 30-year master lease that was crafted by the Attorney General, James Shannon, 30 years ago. It's going to expire this December. And what it does in Section 11A is hit directly, point on, an interpretation of what those words mean that we contest that Judge Edwards got wrong. Because when someone in that manufactured housing community would go to sell, the Section 11A, which is entitled Lot Vacancy Rent Increases, says that a new tenant shall be regarded as a member of a dissimilar class for the purposes of GL 140, Section 32L2. Now you will hear, well, that was a settlement.
Mr. Kraus, I think Justice Kafka has a question.
Justice Kafka.
Mr. Kraus, I'm trying to understand how we're going to have any uniformity if, I mean, obviously there's going to be turnover in these manufactured home communities, right? There's going to be different people arriving at different times. Does that mean once we've got one change, everything is subject to the latest purchaser of a lot?
Well, Justice Kafka, the statute and the regulations provide that fair market value would be controlling. So that is defined in 1001, the definitions, as what a willing, literally a willing lessee and a willing lessor would agree to. And they're afforded an opportunity for a 5-year minimum, a 5-year lease under the statute. Yes, there can be tiered rents within the community. Why?
Isn't there going to be everybody, if you can if once someone new comes, you can change the lease terms, what does it mean for any rule or change in rent which does not apply uniformly to all manufactured home residents of a similar class shall create a rebuttable presumption? Don't they want uniformity throughout this? I'm just trying to understand if you, whenever the time changes, the amount can change. Isn't there no uniformity whatsoever?
Well, and I'll point your attention to the concept of vacancy decontrol, which was a large point in why rent control expired in '94, except for manufactured housing. Market conditions control what you and I enter into by way of a lease or a purchase of a home. The fact of the matter is that someone who bought 20 years ago is not going to have the same rental conditions as someone who buys 20 years later is part of market conditions. If as you take it, in 2006, when Hometown America purchased this community, the rents for the pre-existing tenants were $292. They did an analysis of market conditions and determined that the market at that moment in time when they purchased was $388. They could have raised everyone's rent up to $388, but they didn't because they didn't think it was fair. And there have been no prohibition against them doing that. There's no rent control, there's no prohibition. The direction, the standard is what is the market rent. The uniformity I suggest to you is, for instance, if someone comes in, a change of rule is an easy example. There's a dog rule. And one of the tenants is treated differently with respect to their neighbor about a dog. But the change in rent is a different story because that is really dictated by the time, the point of entry where you enter into the manufactured housing community. Landlord-tenant law is based upon contract, an agreement. And as you'll see in the amicus briefs of the MHI, the MMHA, time is a critical factor when you determine what the rent is.
Mr. Krause, I'm going to ask one more question because I know my colleagues want to jump in. But the classes the judge created, the 5 different classes, I don't understand why your ownership interest in the home as opposed to the lot matters. Why would it matter whether I own half of that, if I own half of that manufactured home or not? The issue is whether I have a contract about the lot, isn't it? Why is the ownership interest of the trailer or the manufactured home matter at all?
Well, Justice Kafker, if I own the home, the manufactured home, and I rent it to you, for instance, and I get a substantial return over and above what the rent is charged for the lot rent, why should you be treated as a resident for the purposes of the statute? The statute and the regulations very clearly define what a resident is and what a tenant is. A resident is someone who typically lives in a manufactured home. A tenant is someone who lives in a manufactured home in the community who has an occupancy agreement. There's no consideration. If I'm an investor and I own 10 of these homes, there should be no consideration of whether I am a resident because I'm not under the statute and the regulations.
Yeah, but the issue, right, is who has rented the lot, right? I just don't understand why we're caught up in the relationships between the people who own the manufactured home, because it's really it's you've rented the lot. It just doesn't seem to me meaningful whether I have a half interest in that manufactured home or not, because the only thing that's being rented is the lot.
Well, then you have to make a factual inquiry, Justice Kafker, as to who's paying the rent and whether that amount of money is in excess of what the lot rent is.
I just need to know who leased the lot, don't I?
Well, take your, for instance, someone owns it but doesn't live in it and rents it to a third party. What we're saying, and the court, Judge Edwards agreed, those people are in a different situation as to the statute because the resident is paying the lot rent. The owner may get far in excess of that, but that's not the issue. The issue is the lot rent. And what you're talking about is an owner profiting in excess of the lot rent. That was the critical issue here in the evidentiary hearing on 93A.
That's all I have.
I have a question. When I look at that statute, it's rampant. Resident runs through it, but they never use the term owner. They never use the term lessee. It's always resident. What impact does that have on this argument?
Your Honor, I think it's the crux of it. Justice Cipher, resident is a defined term in 940 CMR 10.01. And as I indicated, it's someone who typically lives in a manufactured housing community. A prospective tenant, as these plaintiffs were after January 2006, there were
No, they're prospective residents, aren't they? There's a difference even between a tenant and a resident.
Yes, the regulation defines the difference between a resident and tenant as someone who has actually a written contract. A resident in 1001, it says someone who typically lives in a manufactured home. A tenant is someone who has a contract. In fact, if you look at 32L3, the next section, it talks about choice of dealers in purchasing a manufactured home by prospective resident. There's a significant difference. You cannot treat someone who visits the park and is not become a resident. If you look at the amicus brief and the motion for reconsideration, where the expert opinions of Webster Collins about time of entry and Dr. St. John, once you're in a park, you're a captive audience. You have a contract. You live by rules and regulations. There are restrictions. There's an entire body of law that pertains to someone who's a resident that does not apply to non-residents applicants. It is a simple, significant difference. And to otherwise interpret it that way would be making an absurd result of the statute. As Justice Lank wrote in Commonwealth v. Morgan, the court wants to avoid absurd results. And in fact, you try to build a consensus of a reasonable interpretation of the statute. And that's what I think would require in overturning the interpretation of Justice Edwards.
Any further questions? You could sum up, Mr. Kraus, if you wish.
Yes, Justice Gaziano. As I've indicated, I think that based upon statutory interpretation, which this case falls under, that this court has consistently as a full bench, and I point your attention to Laszlo v. Commonwealth, what you're trying to do is understand the legislation as a whole to make it make sense. You cannot treat applicants as residents. You cannot otherwise treat them as though they live in the park. And if you look at that master lease, some would argue, well, that was based upon a settlement agreement. I suggest to the court very strongly that the interpretation that was drawn in section 11A is right on point. It is a dissimilar class when someone under that master lease came in 2 years after its inception. What the settlement was is how much the rent could go up and how many times it increased for that particular lot. That was the terms of the settlement. As provided in section 11A, it could go up 10% and it could change 8 times over the course of the 30-year master lease, which incidentally is expiring this December 31st. It is clear, it is very clear that Judge Edwards, without any guidance, without any foundation, without any standard, interpreted the statute in a way that just does not make sense. And it is inconsistent with the regulations. It's inconsistent with the findings of the Attorney General. I commend you to read the letter of Daniel Less, the Assistant Attorney General, who indicated, yes, it is absolutely positively possible that new residents would pay a higher rent. Why, Justice Kafker? Because they came in at a different time, under different circumstances, with different market conditions. The fact is, if you're, under your theory, Justice Kafker, or your question, someone who came in 20 years later would be paying the same amount as someone who came in 20 years earlier. It doesn't give any consideration to increased costs, time of entry, CPI, all the expenses that are associated and bundled with a landlord-tenant relationship. And I ask that you—
Can I ask one more question, Justice Gaziano?
Certainly.
The you have 5-year leases here, right? You're required to enter into 5-year leases, Mr. Kraus?
At a minimum, Justice Kafker, yes.
So I take it you could, because I agree with you that this is supposed to be fair both to the owners of the community as well as the owners of the units in the community. But could they raise rents? Okay, you enter into a 5-year lease, but there's a progression in the amounts that people have to pay over the 5-year period, and at the end of the 5-year period it's going to be renegotiated. Is that a way to providing an ability to have a uniform increase in rents that apply, or is that prohibited somehow?
No, unless you're in a rent control community. And the rent control statutes, there's usually six considerations, all of which are based on time, except one. 5 considerations. So for instance,
I understand time changes matters, but I'm trying to make sense of both the statute that requires uniformity and your point about time. And I could see then that the leases, because they have to be 5 years, would provide for increases during those 5-year periods. And if you came in on the 4th year, you'd start at that higher amount. It seems to me that there's no uniformity when you can just, as soon as one person changes, then everything is a free-for-all.
but Justice Kafker, I would commend you to read the statute as a whole,
Yeah,
with the language, because remember, it says that it creates a rebuttable presumption that such rule or change of rent is unfair. And the lower court never reached that consideration about fairness, as you indicated, both to the landlord and to the tenant. We are required under the statute, every time we amend, alter, renew our occupancy agreements, to offer at least a 5-year tenancy. And that is based on a fair market rental rate, which is, as the regulations indicate, what a willing renter and a willing landlord enter into. It's not confined by past numbers. It's done by fairness and by market conditions. And as you'll see in the declaration of Stephen Braun, who's the co-president of Hometown America, which is a nationally recognized and in superlative operator, they did a market analysis. They determined that at that moment in time, January 27, 2006, when they purchased this community, the rent should be $388 under market. They could have raised everyone. So the consequences of what you might interpret, Justice Kafker, is that the rents will go up, that they won't be stable, that everyone will not get the benefit of the bargain of their time of entry. And that perhaps may be the unfairest point of all.
Thank you, Mr. Kraus.
Thank you, Justices.
Is it Takapi? I'm sorry, I butchered your name. I apologize. You have to unmute yourself, then you can correct me. I'm sorry, you have to unmute your microphone. And the first thing you can do is correct my mispronunciation of your name. I apologize.
Good morning, Justice Gaziano. Attorney Peter Tekip on behalf of the plaintiff, and may it please the court. This matter does involve the proper interpretation of 140-32L2 and the amount of damages to be awarded under 93A. The lower court properly interpreted 32L2, finding rent within a manufactured housing community must be changed uniformly amongst all residents of a similar class unless the park owner rebuts the presumption of unfairness. Now, the plaintiffs moved for summary judgment on the uniformity, similar class, and rebuttable presumption issues, arguing the $96 change in rent applied to the plaintiffs violated the law. Hometown conceded that all residents had similar lot sizes and services, and their argument was that the change of unit ownership alone established a different class of resident. They deliberately waived the rebuttable presumption issue, arguing they did not need to rebut it. The lower court granted summary judgment to the plaintiffs, finding that a change of unit ownership alone did not establish a different class of residents. Failing to address the burden shifting was a tactical error on the part of Hometown, who, after realizing the error, moved for reconsideration. But they sought to provide new evidence, not newly discovered evidence. The motion was opposed, heard, and denied by a written decision. The court did not abuse its discretion. What is an error of law is how the court awarded damages. Plaintiffs were certified as a single class and must remain a single class for the award of damages. The violation of 32L2 is a per se violation of 93A. 93A9 allows any person injured by Hometown's violation of law to bring the action for damage. The amount of damages is the additional rent paid to Hometown. Either 32L2 or 93A limit the recovery to a resident alone. 93A9 further allows any person to bring the action on behalf of himself and other similarly injured persons. So in this case, each plaintiff represents the interests of all the homeowners, residents, tenants, and subtenants of a particular unit, which must result in awarding damages on a per unit basis. Reducing damages by creating 5 subclasses was an abuse of discretion and clear error of the law, which will require a remand. On remand, damages must be recalculated on a per unit basis as Hometown continues to collect the excess rent from the plaintiffs. The award of attorney's fees and costs was required by 93A. The court did not abuse its discretion in making that award. And since this is an appeal under 93A, the plaintiffs are further requesting their appellate attorney fees and costs.
Can I ask, I mean, time matters. So how does, I mean, someone who entered into a lease 4 years afterwards is in a different position. How does the owner of the community itself adjust for costs over time, in your view? What do they do? Because it can't be frozen in time forever, right? Or is that your argument that the initial amount you pick is what you're stuck with forever?
Absolutely not. And I certainly agree that there is a mechanism under 32L2 to raise rents over time. And that's exactly what Hometown did here. Now, they bought the property in January of 2006, but in June of 2006, they raised the rent park-wide for everyone in the park by $15. And they've increased the rents every year on June 1st through now. What the difference is they found that when they had a new owner come in, that they charged this premium rent, this extra $96 too. They had a procedure in place where they were able to increase rents over time for the existing residences within the community at a fair and uniform level. This was just something that they did in addition to their annual increases in rent.
So your view is that's the way they increase and take into account time, is by these additional amounts per year in the lease itself. And that works even though you've got 5-year leases that are starting at different times. It's not a problem.
Well, that's an interesting point. And 32P does require the park owner to offer a 5-year lease at fair market rent, but it doesn't require the resident to accept that offer. You may have a situation where you have someone that is under an existing 5-year lease, and maybe that's the consideration for them having a different level of rent, which brings in line with the ability to rebut the presumption. Now, the legislature gave the rebuttable presumption to the park owner. So if you have, certain conditions in a park that apply, then they can certainly use that to rebut their presumption of unfairness and demonstrate that it was something that was done according to 32L2.
Go ahead.
Oh, thank you. On the issue of similar, are the only 2 factors that really are at play services that are offered in square footage of the lot?
Well, those are 2 that were outlined in the guide and 2 that were brought up by Judge Edwards on his opinion below. I don't think that the guide or Judge Edwards or the Attorney General's letter limits it to those 2 alone.
So I'm curious as to what else how else we would find similar. So could you expand on that if possible?
Yeah. Well, for instance, if there was, because this was a purchase of a park in 2006. And obviously, Hometown acquired all of these residents from the previous owner. So if there was a contract with a previous owner for a certain amount of lot rent, and they were contractually bound to those 1 or several tenants, that might be enough to put those in a similar class of resident. And again, bringing back in the rebuttable presumption, if that were the case, then that is how Hometown would be able to demonstrate that they are in a dissimilar class, right? They have something that they don't share in common with the remainder of the group. I think that the Attorney General's letter is very clear that it does apply to new and existing residents, and that it's a fact-specific inquiry that principally relates to the lot sizes and the services received. But I don't think it forecloses the ability for a park owner to try and demonstrate a dissimilar class by some of those.
Thank you.
There are other expenses, right, that have to be exactly, if they're capital improvements, those have to be uniformly distributed, right? Equally, right? They can't be different amounts for different tenants, right?
That is correct.
So there's other parts of the community have to be exactly the same. Other costs incurred by the community have to be exactly the same besides
That is
the
correct.
rental. Can you address the issue of the word resident? Because it seems to complicate this class discussion, because it would be simple, I guess, if the statute said, you know, the leaser of the lot, but it doesn't. It says the resident. So does that justify what Judge Edwards, the distinctions he drew? Because some of the people who rented the lot are not residing in the manufactured home, right?
That's correct. And so the term resident is not defined in A through S inclusive. And without the benefit of this definition, it should be its plain meaning. But under 32A through S inclusive, the words homeowner, resident, and tenant have been used somewhat interchangeably. And I would point to 32J, which deals with summary process, which uses the term homeowner or person holding under him to describe who a park owner may evict. And the final paragraph of 32J says, a resident who has been evicted from a manufactured housing community shall have 120 days after such eviction in which to sell the resident's manufactured home. So it clearly uses the term resident in the context of the homeowner, or the person that's ultimately bound to the park owner for the payment of lot rent. Now, as you correctly identified, in this case, the issue of damages as it relates to residents, I don't read 32L2 to require that the resident be the one that's awarded damages. You have to have a resident for a violation of the law, but 93A9 allows any person to bring that claim forward as long as they suffered actual damages. So you look in the case of Mr. Harris, who bought the manufactured home in Oak Hill for his son, did not charge his son rent, always paid the lot rent to hometown directly, and the court found that he was entitled to damages. Clearly, he's not a resident under the CMR definition, but he's ultimately the one that's bound to hometown for the payment of lot rent, and he should be the one that receives the benefit of the award.
The only people who have privity of contract, right, are those who sign the agreement for the lot. I'm just trying to understand how somebody else can sue. They have no contractual relationship with the owner of the community, right?
I agree, and that's part of the argument put forth in the brief, is that the only person that's contractually bound would be the person that signed the occupancy agreement with hometown, the one that would be subject to an eviction under 32J. And so again, you have the term resident used essentially to mean the person that's contractually bound to hometown for the payment of the lot rent.
And what is the precise statutory language we're looking at to determine who's entitled to damages? It's what is the language in the manufactured home statute that we should be reading?
So 32L2 under 32L7 is a per se violation of 93A. So 93.
I get the 93A part. I'm trying to understand how we interpret the word. Is resident built into the statute for damage purposes? I'm confused by who the victim is here, who the statute entitles payment, because the person who owns the home may not be the same person who rents the lot. The person who rents the lot may not be the same person who resides in the home. So it's confusing, and I'm trying to figure out what the statute says on that particular point. Not what 93A says, but what the manufactured home statute, the language we're interpreting on that.
And again, I would point to the sections that use, resident, tenant, and homeowner somewhat interchangeably. Specifically, 32J is one instance where it is used almost exclusively to represent that the homeowner is the one that the park could evict, and that the resident is the one that would have 120 days in which to sell the resident's home. So, you have a specific example where the term resident is used basically to describe the contractual relationship with the park operator, and who is ultimately bound for the payment of lot rent.
So if let's just do this for a second. So I own the home, I own the manufactured home, but I'm letting my child, adult child lives in that manufactured home. Who gets the damages here?
Well, it would be whose hometown collecting the lot rent from, which is certainly easy to determine. Right?
Okay, but so if it's not a family relationship, so it's Justice Cipher rented the lot and she sublet it to me. Even though I'm the one who's getting kicked out of here, she's the one entitled to the damages, is that right?
As long as she's the one that was paying the lot rent directly to hometown. I think if there's a subtenancy agreement,
Even though
which
she's
typically would
not,
be required.
because she's not a resident by any normal meaning of the word, I'm the resident.
Correct. Yeah, so if you, Judge Cipher is the one that's contractually bound to the payment of lot rent. You know, again, this is a violation of 32L2, which is a violation of 93A. So if the violation is found, the hometown discharges the liability by paying the damages to the person that came forward. And it's up to that person to distribute the money, you know, because we're talking about rent that was illegally collected over and above what should have been.
So, but again, if Justice Gaziano owns the manufactured home, he leases the manufactured home to Justice Cipher, who then subleases it to me. In your view, Justice Cipher is the only one who gets damages here. And that's why Judge Edwards' division of this into the three of us was confusing and improper under the statute, even though the statute uses the word resident.
I think it's confusing and improper because under 93A, right, and this was a 93A case where we sent out notice to one person. That person represents the interest. In this case, Justice Gaziano would represent the interest of Justice Cipher and Justice Kafker. And if the award ultimately goes to Justice Gaziano, it's for him to distribute between Justice Cipher and Kafker if he chooses to.
93A can't determine who is responsible under this manufacturing home. We've got to figure out who is owed damages under the manufactured home statute, not under 93A. 93A is just because you violated this, I think, but again.
Well, it's the actual damages, right? And so finding the person that was obligated to hometown for the payment of lot rent is the real, you know, kind of consideration that needs to be made. Once you have that determination made of who was obligated to hometown for the payment of lot rent, then the award of damages should be on a per unit basis. I don't think the subclassing, which was done here, specifically to you know, homeowners and people that you know, one person came forward but they might have had a spouse. I mean, I think it's particularly egregious in those cases where you know, you clearly have one person that's coming forward representing the interest of the entire home.
I have a question.
Sure,
Um,
certainly.
Yes, what was the, do we know anything about the legislative purpose of the statute, the community, housing community, manufactured housing community law? Do we have anything in terms of legislative history or anything about who it was that they intended to protect, legislature intended to protect?
No direct legislative history, very little case law on the subject. 32A through S have always been interpreted to provide comprehensive and substantial rights to owners of manufactured homes. That's cited by Danis v. Longo from 1999. And the unique nature of housing where the homeowner owns the unit and rents the land upon which it rests. And then you have the Lays v. RHP case, and according to Greenfield Estates, it says both the legislature and the courts have interpreted manufactured housing to provide a viable, affordable housing option to many elderly persons, families of low and moderate income who are often lacking in resources deserving of legal protection. But for actual statutory interpretation arguments as far as legislative history, there is very little.
Right, so we don't really know, then you're saying that whom the legislature intended to protect, the residents, the owners, the lessors, the sublessees, who do they intend to protect? I mean, who's likely to be the low-income person here? The resident, right?
That is correct.
So this is intended to protect the resident. And yet you say the damages wouldn't go to the resident would go, the damages would go to the owner.
Ultimately, the one that's responsible for the payment of the lot rent. And I think that's how resident should be interpreted as part of the general reading of 32L2 and the use in A through S inclusive of the terms resident, tenant, and homeowner being used.
Okay, thanks.
Thank you, Counsel.
Thank you, Your Honor.